One of the questions I get from clients a lot is when they've been arrested for a domestic violence case and they're facing domestic violence charges in court. And the person that they are alleged to have abused has given a statement to the police that resulted in the charges being filed. Whether or not that person, in other words, the victim, can change their story to help my client's situation. And by changing their story, will they get into trouble and face criminal prosecution themselves for changing their story? The answer is generally no. And that's because prosecutors see the emotional turmoil that the victim to domestic violence goes through as being understandable. And one of the understandable aspects of it is the common practice of recanting an original statement. And so because of that understanding, the district attorney's offices and the prosecutors don't look at the person as a liar, but someone who is simply going through the usual turmoil of being a domestic violence victim. Now, the situation can change if the person changes their story while they're testifying in court. Now, when you testify in court, before you are allowed to start answering questions, you must take an oath to tell the truth and the whole truth, and that if you don't tell the truth, you could be subject to prosecution for perjury. Now, that could happen to the person if they change their story, but it rarely, if ever, does. And for the very same reason that they're not prosecuted for changing their story to the prosecutor and to the police. And again, that is the understanding that this person is in the throes of the emotional turmoil of a domestic violence case. So it's always better to be safe than sorry and stick to the truth. But generally speaking, if the victim to a domestic violence case changes their story in a significant way, they're probably not going to get themselves in trouble.